Hi, this is Fred Neiman, a New Jersey probate and estate planning attorney, talking to you today about the inheritance rights of a surviving spouse and children of a deceased parent. I took a couple video takes of this topic a little while ago, and frankly I discarded them all because I thought it was a little too confusing. So I'm going to try to dummy it down mostly for me, and hopefully that will help you. First off, if you're married to your spouse and you had children together, you as the surviving spouse get 100% of the estate. The kids get nothing. If your husband or wife had a will, as long as they leave you a minimum 1/3 approximately of the value of the estate, that's what you're entitled to. In other words, the will of your spouse will control unless they try to totally disinherit you, whereupon you can make a claim against the estate. Where it gets real tricky and where the real problems generally take place is when there's a second or later marriage and the deceased spouse either disinherits the second or subsequent spouse or leaves everything to the second or subsequent spouse, and the kids of the parent's original marriage make a claim against his or her estate. And there the law is very clear. The surviving spouse without a will does not get 100% of the value of their deceased spouse's estate. It gets distributed between the spouse and the children of the original marriage. So the only way to avoid that is to make sure your second spouse, or if you're in a second or third marriage, make sure that his or her will is very clear that everything goes to you. Otherwise, New Jersey will divide the estate between you and the deceased spouse's children from their original marriage. If you have any questions or if there are any problems that come up regarding the subject matter of this video, please do not hesitate to contact me. It's my pleasure to be of assistance to you.